Oh, you're watching 13 News Now at 4:30. I'm Connor Reel.
And I'm Janet Roach. The judge has thrown out all charges against former Richneck Assistant Principal Ebony Parker. The defense moved to strike the case this morning after the prosecution rested. Judge Rebecca Robinson ruled the Commonwealth failed to prove Parker's actions amounted to a criminal offense, noting there is no legal precedent for charging an administrator under these circumstances. Parker sobbed out of relief as all 8 felony child neglect counts were officially dismissed. And Madison Schlegel was in the courtroom all week. She joins us again with 13 News Now analyst Ed Booth for more insight on this case.
Yeah, thank you, Janet. And again, Ed, you and I have talked about this case ad nauseum already today, but one of the things that came out of the judge's mouth this morning is that there truly is no precedent in this case. We just heard it a little bit there. Knowing how historical this case has been over the last 3 years, and this is the end of a saga that we've followed for the last 3 years, how would you say that the lack of precedent maybe impacted the outcome of today?
Well, I think it's another way of saying that this is an unusual situation, an unusual charge. You know, there's a lack of precedent for anything that's new. I mean, if you change a law, you know, the first prosecution under that change, you know, doesn't really have precedent. So I think it's another way of saying that this is an unusual set of facts, an unusual theory of liability, rather than precedent in like the pure legal sense, like we know what to do because courts have done it before.
Right, and this was a case where they had to prove beyond a doubt the guilt here, and maybe some of that evidence was spotty here and there. Do you think that maybe in the fact that the judge decided to throw this out, there was some error on the side of the prosecution here?
No, I'm not here to give an opinion on whether or not there was error in terms of the way that the case was prosecuted. But what the judge did say is that, you know, these facts as presented, you know, not only could they not get to a reasonable doubt, but that no reasonable jury could construe that to be a violation of the law. Therefore, we don't have to even give it to the jury. That's what the court's saying. I can take care of it myself because I'm not going to let the jury consider it. There's no need because no rational jury could find that there's a crime.
Right, and even though the prosecution is the one that has that burden of proof there.
Absolutely.
But I know we talked a little bit before about the difference between a mistrial and also the judge striking the case down. For the people who maybe weren't watching earlier at 4:30, do you just mind giving us a little snapshot of that discrepancy there?
Well, sure. There was discussion of a mistrial in the case because of some of the evidence that came out and some things that jurors were told not to consider. Now, that happens in a trial. If you have a really, really bad problem, an unfixable problem, the court can say, we're going to declare a mistrial, we're done, we're going to start over and do this again another day with a different jury. Or the court can say, you know, jurors disregard what you just heard and give a curative instruction and trust that they're going to follow the instructions of law. So a mistrial essentially fixes unfixable problems by saying, we're done, we're going to come back and do it another day with a different jury. Curative instructions tell the jury not to pay attention to that. A dismissal on a motion to strike is basically saying, I've taken all of your evidence and I've considered it in the light most favorable to the Commonwealth, and even taking it in that light, this doesn't get to a violation of the statute.
Well, Ed, we appreciate your knowledge here and helping us understand this. I know people at home really value this type of feedback here. Again, that's what we've got here for you with Ed Booth, legal analyst here for 13 News Now. Connor, Janet, back to you.
Madison Schlegel was in court all week, and she joins us again with 13 News legal analyst Ed Booth for more.
Yeah, we figured we'd bring in the experts to kind of flesh out the judge's decision here today. But Ed, you and I have spoken earlier today, and we've kind of delved into the details here. But the judge truly said that this came down to a question of law, and the jury is kind of the one to answer the questions of fact here. So do you mind giving us a little bit of insight of what that means, maybe for the layperson at home?
Sure, of course. So jurors are always the finders of fact. And judges decide the law. And in this particular case, the judge decided, based on the facts that have been presented, that she didn't need to let the jury consider any of those facts, didn't need to get into their credibility. She decided it solely on the law as she saw it and said there isn't enough for the jury to hear the case.
Right, and I think over the last couple of days, too, we've also heard some confusion in testimony in which the jurors were hearing, you know, that object of hearsay, those statements that were put on the record and then struck from the record. Do you think that maybe the confusion in which the questions that the judge answered also due to the questions that the jury had also may have played an impact in this?
Well, I think it's sort of a symptom of what was going on in terms of the judge's view of the prosecution. Now, in any kind of trial, there might be something that comes out and the judge says, well, jury, you're not to consider that. You've already heard it. We can't unring the bell, but it's not so serious as to declare a mistrial, but going to give an instruction that says you're not to consider that fact. And it sounds like that happened here. That happens in a lot of cases.
Well, you mentioned the word mistrial, which we heard a motion towards yesterday, and both the defense and the prosecution had kind of agreed that that would be a motion that they both support here. And the judge ultimately struck that down. Do you mind giving us the difference of what a mistrial would be and then what we saw today, which was the judge striking down those charges?
Well, sure. A mistrial is when you have a structural error with the trial. Something's happened and it's bad enough to where you can't fix it with a curative instruction. We just have to start over and do this all again. It does happen. It's extreme. On the lesser side of things, you've got my example where the judge says, jury, you heard that, but I'm telling you, you're not going to consider it, and we're going to trust that they follow the law. So a mistrial is an extreme problem with the case that can only be remedied basically by doing it over again. In this particular instance, the judge has said these facts as put on by the Commonwealth don't equal a crime under this statute. So that's not a mistrial where we come back and do it again another day. That's an acquittal. In other words, it's a dismissal of the case.
And you said it would be rare for the Commonwealth to maybe file more charges on this.
Well, yes. I mean, you know, you've got double jeopardy, and that has to match up identically with the elements. But if you think about it, trying to charge a different crime based on the same operative facts, you know, even if legally you were able to shoehorn that in, you know, there are a lot of reasons not to do that, and the optics aren't great.
Right. Well, Ed, we appreciate you making yourself available to us, not only earlier this afternoon, but here this evening. Connor, Janet, back to you.
All right, Madison, Ed, we appreciate it. And to see reaction, analysis, and more of the Richneck Elementary School trial, head to the 13 News Now app.